I'm quite worried about where this country is going following the Trump appeal, in which Trump's lawyers argued that he is immune to these criminal proceedings for a variety of reasons, at least those pertaining to insurrection claims. I'm concerned because the judges, now they may be just trying to play devil's advocate, but in their questioning, you are wondering how daft they could be and still make the bench. Trump lawyer argues presidents can order SEAL Team 6 to assassinate rivals in stunning appeals courtroom exchange. Any honest person who listened to Trump's team's legal arguments would conclude they are sound, rational, and reasonable arguments as to why Donald Trump is immune from these charges pertaining to quote unquote insurrection. However, these judges seem to be too stupid to grasp these concepts, or perhaps they're in fact quite intelligent, but are only playing this game because they're partisan actors and they don't believe in our founding documents and our constitutional republic. Many people are saying that they're woke, and thus they're going to side against Trump no matter what he argues anyway. But I'll give you the simple version, and then we'll play the audio, and I'll show you just how infuriating it is to listen to this hearing. Donald Trump's legal team has made the simple argument, which I believe is sound and likely correct, that any president cannot be criminally charged with an act they committed as president, an official act, unless they are impeached and then convicted by the Senate. Following this, the Department of Justice or state-level prosecution may occur. But short of that, they cannot be criminally prosecuted. Additionally, well, I'll leave it there for now, and we'll get to the other arguments in a second. The reason why this makes total sense. If you allow states to prosecute a president like they're doing now, the president could engage in an official act for the betterment of this country, which could cause problems for an individual state. The individual state could then disrupt the union itself by going after the president with criminal charges. Now, the second point I was going to mention before that is that when it comes to Donald Trump, not only has he not been convicted in the Senate, but they've already brought these charges, which have been effectively dismissed. So the argument goes, if the president punches, a president kicks a guy's dog as president, and then he's not impeached for it, you cannot criminally charge him. Now, additionally, if you do try to impeach someone for kicking a dog and he is acquitted, you can't then try him again. That's double jeopardy. In this, they get into the very serious question of how a president could order SEAL Team 6 to assassinate rivals. Trump's team is correct. As shocking as it may be, the question is not about the actions of the president, but whether or not they are official. And if there is a check and balance on the official proceedings or the official duties of the president, it must go through the constitutional channels. I'll give you an example. The president orders the release of the Strategic Petroleum Reserve to a certain degree. Why? It is an official act and it is for the betterment of the country. However, due to this, it will cause a price spike. Or let's say he restricts the SPR at a time of need and says, we got to keep this saved for more dire situations. Sorry, that means prices will go up. In California, prices go to $10. California gets mad and says this president is engaging in actions which are detrimental to the state of California. I got an idea. Let's launch a state-level criminal proceeding against him, which will result in him being removed from office, and then he can't run again and cause our state harm. That single state going up against the person who was leading the country or running to lead the country is political interference because of their bias. And the state could be bringing biased or false charges against a president to benefit their state. Thus, Congress at the federal level must impeach and the Senate must convict. Let me play for you this exchange because it is hilarious, but I will explain. I will break down for you how even in the instance that the president orders the assassination of his rival, he cannot be criminally charged unless impeached and convicted in the Senate. Let me play for you this exchange.
And so in
And we'll get the audio just right. I'll play for the exchange, and you can, and then I'll break it down for you.
View, could a president sell pardons or sell military secrets? Those are official acts, right? It's an official act to grant a pardon. It's an official act to communicate with a foreign government. And such a president would not be subject to criminal prosecution?
The sale of pardons example is an excellent example because there were allegations about a sale of a pardon, essentially, when it came to President Clinton's pardon of Mark Rich, and the U.S. DOJ carefully and for the very reasons we've emphasized in our brief, decided not to prosecute President Clinton with that because it raised concerns about whether or not a president can be prosecuted for his official acts. There's actually an op-ed in the National Review from Andrew McCarthy.
But your position is that he can't be prosecuted for that unless he's impeached.
Yeah, and that was, as long as it's an official act. I mean, in certain cases, purely private conduct under Clinton against Jones, he'd be subject to prosecution for that as long as he's not in office. But as long as it's an official act.
Could a president order SEAL Team 6 to assassinate a political rival?
Yes.
That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
No.
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes. There's a political process that would have to occur under the structure.
I just can't stand any of these people. I'm sorry. I don't live in this reality. I don't understand what John Sauer is trying to argue to this judge at all, nor why the judge is even asking the question. Qualified yes. No, the answer is no. If Donald Trump, okay, let's stop here. If Joe Biden right now ordered the assassination of someone running for president against him, and Congress does not impeach, you cannot criminally prosecute him. Have a nice day. There's no reason to have an argument with the judge. No, it's a qualified yes, pointless. And the judge is clearly asking a question which makes no sense. Now, to be fair, I'll be fair to the judge. The judge may be playing a kind of devil's advocate push. Tell me what you mean. So you're saying this? My response to the judge would be like, you are correct, Your Honor. Absolutely. And for the reasons of, there are circumstances in which Congress may take it upon themselves to decide the president's actions were not high crimes and misdemeanors. We rely on the bold and honorable word of our members of Congress to determine if the president has engaged in high crimes and misdemeanors. Why? For the reasons stated earlier. We do not want a circumstance in which an individual state seeking to prevent a president from winning to remove him. Case in point, I'd like to bring you back, my friends, to 1860, when Southern Democrat states did not cast a single vote for Abraham Lincoln. This is true. Now, many people incorrectly state that Abraham Lincoln was pulled from the ballot. The reality is, back then, that's not how it worked. The parties would issue their own ballots that people could then bring in, basically saying, here's who I want to vote for. The Republicans decided there was no point in even engaging in the South because the South were on the verge of secession, did not want Abraham Lincoln to win. So what's the point? They would have to win elsewhere. What did the South do? Did Southern states criminally charge Abraham Lincoln, arrest him, and then take him off the ballot? That's not what happened. The South voted against him. Imagine this scenario, and there may be some historical context that makes it close to being true, but imagine this scenario where Virginia, with deep Southern sentiments, pro-slavery, decided, look, guys, the year is 1860. Abraham Lincoln is on the verge of winning this election, and that means slavery is out. How about we criminally charge him and accuse him of committing a crime while, that way he can't run. That being said, he was not yet president, so it's a bit of a different scenario. But imagine that had happened. That's not even where we went. Now, don't get me wrong. It's probably not a great analogy to go into the Civil War. Abraham Lincoln wasn't president at the time. Imagine you get Ulysses S. Grant. He becomes president following the Civil War. Imagine if Southern states under Reconstruction said, I know a path forward. let's criminally accuse him of actions he engaged in as president so that he can. You get my point. They would use individual state that was upset over the way they were being treated by the federal government would just at the state level criminally charge the president, which is what we are seeing right now. We're seeing this. Well, and more particularly, I mean, Trump is being charged in numerous state level issues, but federal level as well. And he is immune. I am flabbergasted at the point of these questions. Let me give you the example. I'll break it down. Let's say that there is a powerful political individual in this country, and the president gets word, official documentation from the Senate Intelligence Committee or the Intelligence Committee in Congress. They say, Mr. President, this man who's running for office will be meeting with Vladimir Putin to deliver nuclear state secrets. Here's the proof. Here's the video. I recommend we bring this to a judge immediately to sign off on a warrant to prevent this from happening by any means necessary. This information getting out to our adversaries could result in the destruction of these United States. The president says, my God. So immediately, both branches file with the judiciary, maybe straight to the Supreme Court, who knows, whatever, how it would work. And they'd say, look at the evidence. And the judges go, this evidence is overwhelming. Absolutely overwhelming that this high profile political individual in the United States is seeking to sell military secrets which could destroy this nation. Mr. President, we sign off on the warrant. You must stop this man by any means. Now, that is a due process hearing with checks and balances. The president then says, locate this man. They find out he's in Yemen. Now you got a challenge. We're not at war with Yemen. But they decide, in order to prevent the sale of state secrets in this illicit deal, they dispatch SEAL Team 6. They enter Yemen through an agreement with the Yemenis government, locate the high-profile individual, attempt to arrest him, but the individual draws a weapon, and then bang, SEAL Team 6 takes him out. Several states are outraged. But in this extremely unlikely circumstance, with due process checks and balances and a crime of treason being committed, the president acted within his official duties to assassinate a political rival. Congress is then offered up the question by advocates of that political individual, and they say, we must impeach. And members of Congress present the evidence and say, no, this was not a high crime or misdemeanor. In fact, it was a legitimate official duty to protect these United States. Thus, there is no impeachment. Could a state then bring criminal charges against Trump? The answer is absurdly and obviously, I shouldn't say absurdly, but unambiguously, no, they cannot. What they're trying to make it seem like is a story where the president is like, I'm going to stop my political rival. Yeah, okay, listen. In the event Joe Biden or Donald Trump or whoever, for no reason, ordered the assassination, that is not an official act. You can argue that they would try and argue it was and justify it. But if Congress saw no evidence to justify such an action, the impeachment would be unanimous and instant. And the Senate would easily convict. In that circumstance, any state and every state with jurisdiction should then file criminal charges, including the federal government. That's how the system works. Imagine the argument of the Democrats on this one, that there could be a judge signing off on a warrant with intelligence provided by Congress that a man was going to commit treason, and the president would say, I cannot stop him because I'll be criminally charged for doing so. That's why you cannot criminally charge a president for an official act without having been impeached. I play more of this video for you.
Constitution, which would require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders were much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted?
Requirement.
And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached.
The reason he's saying qualified yes is that he feels that his statement is weak, and it's almost an admission of defeat. Qualified yes, because you think the answer they're looking for and would be more amenable to is yes. I would say unequivocally and unambiguously, Your Honor, the answer is no. A president cannot be criminally prosecuted if they have not been impeached and convicted for the reasons I've laid out. If you'd like me to elaborate, I could. I'm not here to try and make an argument to the judge in such a way that she asked a simple question, and my point stands. No. Now, if you're making an argument about an overt criminal action in a private matter, well, Sawyer already made that point. Yes. If Donald Trump as acting as in a private manner is caught, well, then you've got issues. And there are challenges there, too, because states could make up a bunch of reasons. But the question would be, do they have jurisdiction? And if that's the case, then the answer is no. At the federal level, you still have states' interests and you have biased individuals. So this is why Congress must come to the decision to impeach, and the Senate must have a 2/3 majority. It has to be unambiguous. I'd like to play for you another portion of this hearing, which will make your blood boil. I hope you enjoyed this one.
So I just want to confirm, your position is if President Trump had been convicted after his impeachment trial on incitement of insurrection, if he'd been convicted, then this prosecution would be entirely proper.
Which I would say that if he were impeached and convicted for the same and similar conduct, then that would authorize a subsequent prosecution. So we have many other issues with this prosecution.
Is that a yes?
So I do.
Because I think you said in your brief that impeachment for incitement of insurrection is based on the same or related conduct as that which is in the indictment.
Yes, I agree with that.
So if he had been convicted by the Senate, then this prosecution would be entirely proper, correct?
I would not phrase it that way because there's lots of other problems with this prosecution that we've raised in extensive pleadings to the district court. He could be prosecuted.
Under the impeachment judgment clause, if he had been convicted by the Senate when he was impeached for incitement of insurrection on same or related conduct as what's in the indictment, then this prosecution would be properly brought.
No.
There's a prosecution could be properly brought. This prosecution, which has tons of other problems. I just want to be very clear about that. I'm making any concession that this prosecution is.
All right, let me try one more time. Under your interpretation of the impeachment judgment clause, if President Trump had been convicted when he was previously impeached on same or related conduct as that which is in this indictment, the government could properly prosecute him for that same or related conduct.
Yes, 100% absolutely. What the judge asks twice, if Trump was convicted on that charge, then this charge right now is sound. No! I fear we are in deep trouble. We are a nation that is incredibly stupid and getting stupider by the generation.
Yes or no?
Potentially, provided they qualified with all kinds of other legal doctrines that are violated in this case. So I admit that a prosecution.
I'm only asking you under your interpretation of the impeachment judgment clause, is that proper? Is that allowed?
And I stand on my prior answer. I think we're agreeing.
I understand there might be other reasons why you would challenge this prosecution. I'm saying based on your interpretation of the clause, this prosecution would be properly brought.
No.
I would not say this prosecution. Be very clear about that.
But it's a prosecution based on same or related conduct.
Yes.
This prosecution, which has many other issues related to it, what I would say is that the impeachment judgment clause authorizes the prosecution of a president who's been impeached and convicted by the Senate, which President Trump.
All right, we'll make it a hypothetical. Say a president was impeached and convicted on a charge of incitement of insurrection that is under the same allegations as a criminal indictment. He's convicted. Then the government could bring a prosecution for the same or related conduct, correct?
Don't disagree with that.
Okay.
That's correct.
And then that means that the conduct that's same or related, even if it's official, they he could be prosecuted for it, correct?
If you
Yes.
you're convicted.
Correct. Okay, thank you.
But my question goes to after the fact, and the reason I say that, even though you're challenging that these actions are only occurring while president, the district court's decision was that there is no presidential immunity from prosecution for official acts. It doesn't put a time frame in there. And so that's why I'm going to beyond your investigation. Your prosecution might not come until later, after the president has left office. So are you...
And you can still be impeached after you leave office. And the argument is that a president must carry out very serious duties, which involve life or death in the enforcement of law. And we do not want states or actors within the federal government to be able to interfere with the duly elected president's duties through false charges of criminal activity. It is up to Congress to make that determination first, because that is a democratic process within our constitutional republic for removing a president who is committing crimes. But if our Congress does not agree and they believe the president has done nothing wrong, well, then you don't bring charges. Look, Barack Obama killed American citizens. Should he go to jail for it and be prosecuted? Absolutely. This would require he be impeached. This would require that Congress hold a vote saying, we believe that the actions taken by Barack Obama are high crimes and misdemeanors and then the Senate would have to agree. And you know what? I believe it's totally fine if it happens after the fact, which means the Senate makeup is very different today. Let's say come 2024, you get a mega MAGA wave. 80% in both houses is in upper chamber and lower chamber is Republican. And they say, we impeach Barack Obama. And then the Senate says, we convict him for the killing of Abdul Rahman al-Awlaki. I say, okay, understand. A president engages in an action that you feel is criminal. Congress at the time says, we see nothing wrong. And that's it. End of story. So what happens? The people, in their anger, elect people who vow to impeach. The new Congress comes in and they say, impeach. This president, who is now out of office, gets impeached like they did. They impeached Trump after he was already out of office. And then the Senate says, we agree. Barack Obama, or, this president committed crimes. Then, after he's impeached and convicted, even though he's already after office, that is basically the formal declaration by the voting will of the people through their representatives that the president engaged in high crimes and misdemeanors. The Department of Justice is then instructed to begin a criminal investigation of these actions under the exact same argument brought forth in the impeachment proceedings, and they conclude there is enough for a criminal indictment. A trial is then had, witnesses are brought in, evidence is presented, and they say guilty or not guilty. The Senate convicting is the will of the states. The impeachment declaration is the will of the people. Then the criminal proceedings is a determination of a jury of this man's peers. Did he commit the crime? And they get their fair trial. It's silly, but I think the most frustrating thing is, listening to these arguments from Trump's lawyer. Look, I don't know what the point of saying qualified yes is. You just say, yeah, no, you can't criminally charge a president unless he's been impeached and convicted for same or similar conduct. And what that means is if a president is accused of kicking a dog, you can't criminally charge him if he's been impeached for misappropriating files, because there has to be an impeachment for the individual acts he had taken. I think there's potentially an argument to make that once he's been impeached and removed for any reason, you can criminally charge him for anything. And what the reason why is if a president is embezzling or doing something illegal and he gets impeached and convicted, we then say you're a criminal who's engaged in corruption, and we throw all of everything you've done out the window. In which case, then, yes, you come after him for basically anything. It's tough. I'm not a legal expert. I'm not a lawyer. I'm listening to the arguments, and I think it absolutely makes sense. The last thing we want in this country is a biased partisan actor within the DOJ or at the state level targeting the president over actions they took officially based on intelligence granted to them. Let's say a general goes to the president and says, we have top secret information. This man is a criminal. He's going to commit treason. We must stop him. And the president gets a warrant from a judge presents the evidence from his intelligence officials, and the judge agrees this guy's a risk. He's going to engage in treason, and he's in these secrets, like I already mentioned earlier on. This time, we're not including Congress. Imagine if a state said, he killed the guy, lock him up. No. For reasons that are top secret, I'm sorry, you don't know. I am not an anarchist. I am not an absolutist libertarian type. I believe there are certain instances where, if due process is followed, the president has a right to take these actions. I believe that a law enforcement officer who is being threatened by some crazed guy with a gun has a right to defend himself. And I don't think you should be criminally, I don't think people like Derek Chauvin should go to prison for the rest of his life for duties he took as a police officer. And I'm the guy screaming about the banality of evil all day. I think Chauvin should have been relieved of duty. I think the department itself is at fault and should be overhauled. And the idea that you would, as the public, allow the police training that existed with George Floyd, and then after this guy engaged in what he was trained to do, as anybody who watched the courtroom saw, this was a fact, to then lock the guy up. It's like, look, just following orders is no excuse. But you have to understand the difference in moral lines versus, right, moral lines versus following instructions you know to be immoral because they're under the law. What I mean to say is, using the Chauvin thing as an example, his intention was not to kill. His intention was not, I know what we're doing is evil, but I'll do it anyway. His intention was, this guy is resisting arrest and violent and on drugs. Here's what my training says I should do. That is a basic function of policing. Now, if it was that he was aware this man had done nothing wrong, was not doing any drugs, and said, I'm going to detain him anyway, you got a different question. In New York 10 years ago, I filmed police falsely arrest a man and then lie about it under oath. I didn't really know much of what was happening, but I was informed by the National Lawyers Guild that this guy was a photographer standing on the sidewalk filming police. The police arrested him, falsely claimed that he'd been obstructing a roadway. Those cops are evil. They should be in prison. They should be fired from their jobs and criminally punished. Chauvin was doing what he was trained to do, albeit it was bad training, but it was a guy who was committing a crime that we all agree should not be. You should not be chewing a speedball behind the wheel of a car, who resisted arrest and demanded he be removed, and then Chauvin followed his training. They lock him up for that. There's got to be a way to handle mistakes of official proceeding done in good faith. But I'll leave it there. Next segment is coming up at 4 p.m. on this channel. Thanks for hanging out, and I'll see you all then.